Laura, you may proceed with the program.
Hello, everyone. My name is Laura Pizeski. I am the Vice Chair of the American Bar Association section on Science and Technology Law, and I'd like to welcome you today to our third in our summer series program, Taste of SciTech. It's a program designed to provide free programs for members this summer to give them a highlight of all the exciting topics and things that we're doing in the section. Today, our program is entitled Video Comes to Court When Believing is Seeing, and it will feature our conversation today between our Scientific Evidence Committee Chair, Judge Roderick Kennedy, and and Dr. Sandra Rostovska, who is a Mellon ACLS Scholar and Society Fellow that has been working with our section over the past year to work on visual communications and neuroscience issues in the law. Before I pass the mic over to them, what I would also like to mention is that today really is a taste of SciTech. The program that you're hearing today is just an introduction to a series that we will be doing this fall, starting in September, featuring a lot of the work that Dr. Rostovska has been engaged in for the past year with us. And we also will have follow-up programs through December. And then the other piece I wanted to mention, since we are touching on neuroscience today, is that we are very pleased also to announce that in August, we will also be working with AAAS to do a neuroscience program relating to neuroscience and testimony in the courts. And so I want you to just be on the lookout for information about that program coming up as well. So without further ado, Judge Kennedy, I will pass it over to you and take it away.
Well, good morning, everybody. Last August, we in the Scientific Evidence Committee got an email from Dr. Rostovska, and she was looking for a home for a grant that she got from the ACLS Mellon organization to do research on video evidence in court, its admissibility and its limitations and so on. And it sounded pretty fascinating. It sounded as big as All Outdoors. And through other discussions, it also sounded like a very exciting thing as video comes to court more often, every single day. As a judge, both trial and appellate, I've dealt with eyewitness evidence and experts coming in, and through the last years, experts on eyewitness testimony have gone from a misunderstanding that they actually are saying that an eyewitness might be a liar, to an understanding that everybody has differences in how they perceive and process and remember things. And the experts can put context to an eyewitness's process, which basically affirms that they're telling the truth, but also talks about the ways that truth can be subject to some interpretation. The same thing happens with video, and I think that as more video comes in, the expertise that comes in to talk about how people look at video evidence and process it and what they think about it is going to become more ubiquitous, and I think it's going to become more important. And that's what we're going to be talking about today. And I'll turn it over to Dr. Rostovska from University of Colorado Boulder.
Thank you so much, Laura and Judge Kennedy. Let me share my screen. Here we go. And maybe Judge Kennedy, one confirmation that you can see it well. Okay, perfect. So it's been exciting to be a Mellon ACLS Scholars and Society Fellow with SciTech and the Scientific Evidence Committee, and to work with Laura and Judge Kennedy. My work broadly looks at the legal challenges that are rising from the increasing and ubiquitous use of video as evidence in state and federal US courts. So as a kind of brief overview of what we'll be talking about today, these are really like 5-part points that we'll be making. One, broadly, can video gives us the truth of the matter? Why do we assume that, and how does that work exactly? Then we'll move on with some overview of how people interpret video, what factors may influence visual perception and interpretation. As Judge Kennedy already alluded to, we'll talk more about the parallels, similarities, and differences between eyewitness testimony and video. And then I'll give you just a sense of my own work and where we're heading with the webinar series this year that will go through December. So can video gives us the truth of the matter? I mean, we all know that from cell phones to police body cameras, today's courts increasingly use video as evidence. Yet US courts, from state and federal, all the way to the Supreme Court, lack clear rules and standards on how video can be used and presented as evidence. The underlying assumption is that video evidence need not be governed by unified standards because seeing is supposedly intuitive. And that means that what we see in video is the truth. So I'd like to start by questioning this assumption. Can video gives us the truth of the matter? And to begin, I'll play a very short clip from the ending of a dashboard camera footage that was used as evidence in a very well-known and well-cited case, Supreme Court case called Scott versus Harris from 2007. Now, in this particular case, the Supreme Court had to decide whether a police car chase, which left the driver paralyzed, violated the constitutional protection against unreasonable seizure. The car chase was recorded on 2 dashboard cameras, and the clip here is part of the video evidence. Now I'm showing you just 10 seconds. It's black and white, it's from 2007, it's low quality, and it's a little bit disorienting. So I'm showing it more to give you a sense of the quality of the material and how it was part of the evidence. So lower courts ruled that reasonable jurors could differ as to whether the police had used unreasonable force to end the chase, requiring a jury trial. The Supreme Court, though, ruled 8-1 in favor of the officer, explaining that the case was clear from the videotape and that no reasonable juror could agree with the plaintiff's account that the police had used excessive force to stop the vehicle. In an unprecedented move at the time, the court uploaded the video to its website, inviting the public to confirm that the video speaks for itself and really telling the public, see, you can see it for yourself. Now, social psychologists accepted the challenge and conducted an experimental study about this video, showing that people interpreted the video and the reasonableness of the police behavior differently, depending on their cultural and ideological backgrounds. So I use Scott versus Harris as one example that demonstrates how, contrary to common assumptions, video doesn't speak for itself, providing a single objective window onto the truth. Rather, courts may interpret video evidence differently, even within the lifespan of the same case. Now, why does this matter? Well, the Bureau of Justice Assistance says that if a decade ago it was rare for a court case to feature video evidence, today the estimate is that video evidence is involved in about 80% of crimes. Video evidence today is produced by a range of individuals and automated surveillance cameras for a variety of legal purposes, but without any uniformity in usage and with an underlying faith that video can provide objective access to the depicted events as they really are. The belief that subjective experiences mirror objective reality is what psychologists famously call naive realism. The logic of naive realism shapes how people see and interpret video as well. In court, the opportunity to see a video is often presented as equivalent to seeing the real event. In other words, despite the growing ubiquity of video evidence, there is a tendency to conflate what an image shows with how a viewer interprets it. Naive realism explained this tendency to conflate what a video shows with how a viewer interprets it. And this tendency is well known in the world of filmmaking. As early as the 1920s, Russian filmmaker Lev Kuleshov conducted a famous experiment where he took a shot of an actor and intercut it with 3 different clips showing a coffin, a bowl of hot soup, and a young woman. Let's take a look at this.
The theoretician Lev Kuleshov also experimented with film editing. In his most famous study, he took a shot of a Russian actor and intercut it with 3 different objects: a bowl of hot soup, a distraught woman draped across her husband's coffin, and a little girl playing with a teddy bear. When audiences saw the film, they raved about the actor's performance. How hungrily he looked at the soup. How sorrowfully he gazed at the woman. And how tenderly he watched the little girl.
I like this example because it illustrates just one way in which people's interpretations of moving images may, without their conscious awareness, be influenced by factors other than the content of the image itself. In this case, the visual context of images shown after the clip in question. Yet people are largely unaware of these various influences on how they perceive and construe what they see in images. So let's look at some classic studies on perception. And here I want to play 2 clips. You may have seen them before, and that's okay. I would still ask you to play along, and then I'll ask you to report what you see in both videos. So let's start with the first video. It's from a very famous classical study on perception.
This is a test of selective attention. Count how many times the players wearing white pass the basketball. How many passes did you count? The correct answer is 15 passes. But did you see the gorilla? This video is from research by Daniel Simons and Christopher Chabris and is copyrighted. It is available.
So let me ask you, maybe by the showing of the reaction show of hand feature on Zoom, how many of you have seen this video before? Some of you. Okay, more of you. Now, how many of you were able to see the gorilla, to spot the gorilla? Some of you. It's surprising how this study is from 1999, and I show it very often in my large 100+ students classes. And each year I believe that, it's been enough around that, everybody would see the gorilla, but it's still true to more or less to the initial study where about half of the people see the gorilla, half of the people don't see the gorilla. Now let's take a look at another video, a follow-up video to this one. What happened? Here we go.
For use in talks.
Here's the second video.
The monkey business illusion. Count how many times the players wearing white pass the ball. The correct answer is 16 passes. Did you spot the gorilla? For people who haven't seen or heard about a video like this before, about half miss the gorilla. If you knew about the gorilla, you probably saw it, but did you notice the curtain changing color or the player on the black team leaving the game? Let's rewind and watch it again. Here comes the gorilla, and there goes a player, and the curtain is changing from red to gold. When you're looking for a gorilla, you often miss other unexpected events. And that's the monkey business illusion.
So let me pause for a second. How many of you saw the gorilla this time? Okay, way more than the first time. Now, how many of you saw the curtain changing colors or one of the team members leaving the game? Less than that, right? So I show these examples along with the Kuleshov effect, really to make you curious about how visual perception and interpretation work. And oops, it's easier to go back and forth the slides when we're in person. Here we go. Presenter view, here we go. So what I hope to emphasize here is that how people see and interpret images is driven by cognitive, social, and even technological factors. In other words, not everyone who sees a video interprets it in the same way. So let's unpack why and how people's interpretations of video can vary widely. I'd like to highlight some excellent studies on visual perception and interpretation that psychologists, legal scholars, and visual communication scholars have worked on. First is a study conducted by a team of researchers led by psychologist Eugene Caruso, who were interested in exploring whether different video qualities like replay speed affect judgment. Now, in one of their studies, they modeled the legal context for judgment of intent. Participants were asked to imagine themselves as jurors in a criminal trial and then watch real surveillance video with an accurate digital display of elapsed time, depicting 5 seconds of an attempted robbery that ended with the assailant shooting a store clerk. Participants were randomly assigned to watch the clip at regular speed or slow motion. And then study participants indicated whether the person with the gun shot with the intention to kill the victim and the extent to which the action was performed with willful, deliberate, and premeditated intent to kill. Now, I'll play the 5-second video at regular speed. Very brief. Now, the same video with the same question, but slowed down in slow motion. Now I'm going to stop share for a moment because I want to ask you, what do you think is the result? Did the replay speed affect people's judgment of the depicted actions? So I'm just curious, what do you think is the result of this study? Did the replay speed, playing the video in regular versus slow motion, had any impact on people's judgment of the depicted action?
So far, one person says, yes, thumbs up.
Yes, thumbs up. And that person is right. Let me go back to my slides. That person is absolutely right, because I'm going to show you the clip from the original study. It turns out participants who saw the slow motion versus regular speed video felt that the action was performed with more of a willful, deliberate, and premeditated intent to kill, and that were more likely to conclude that the person with the gun shot with the intention to kill, basically. So this study is a great example of what scientists call exogenous biases. Factors external to the viewer, such as features of the medium or the viewing context, can influence the interpretation of the information or the action depicted in the video. So I'll show you one more example. Here, I'll show two videos that were part of a series of experiments conducted by a research team led by behavioral researcher Broderick Turner. It's a longer study, but for the purposes of today's session, I'll show you just two videos depicting the same incident of police shooting, one on body camera and the other on dashboard camera. The researchers were interested in measuring judgments of intent as well as blame and recommended punishment. So did the officer act intentionally? Also, how do you assign blame? What's the recommended punishment? Now, here is one of the videos. And here is the other video. Now, this study found that body camera participants gave lower intentionality ratings than the dash cam participants, and body cam participants also gave lower ratings of blame and recommended punishment than dash cam participants. In other words, same incident depicted on two different types of cameras were interpreted differently by this study participants. So there are different exogenous biases that can influence how people interpret video. And some of those that we discuss include video's quality, like replay speed. This was the first study. Slow motion results in greater judgment of intentionality in the depicted action. Type of video, viewers of body camera footage are less likely to judge officers as having acted intentionally than those who watch dash cam footage. But also camera perspective. Now, I don't know how many of you are aware, but these are very famous series of studies that show how a criminal confession is recorded, whether you're seeing only the suspect, only the officer, or both in the frame, influences assessment of the confession's voluntariness and the suspect's guilt. But there are also endogenous biases internal to the viewer, such as prior attitudes, current motivations, and group identity. Roseanne Summers was interested in whether people's general feelings towards police affect their judgment of videos depicting interactions between citizens and the police. The study participants were randomly drawn from a demographically diverse panel of 40,000 US citizens. What she found is that identification with police does affect judgment. Viewers rely significantly on their prior beliefs to determine what happened in the videos and what the legal consequences for the parties involved should be. Now, you remember the test of selective attention that I showed? Now, a team of psychologists that you see here modified the famous study on selective attention. they recruited white women participants and they asked them to watch similar video with teams playing basketball and an African American versus Caucasian man showing up in the video. Now, they also asked this woman to report on interpersonal goals, some closer to them, others not. So for example, imagine this is a coworker, imagine this is a romantic partner, etc. And here's what's interesting with this study. As interpersonal goals became closer to the self, the study participants were less likely to see the African American man in the video. In other words, when there's no social goal involved, they immediately see the African American man in the video. But when they have interpersonal goals, the closer those goals are to the self, the less likely they are to notice the African American man. Now, of course, you remember the Scott versus Harris example that we started with, and the study on this video showed differences in interpretation based on cultural and ideological differences. So there are different exogenous biases that can influence how people interpret videos. These include prior attitudes, such as identification with police affects interpretation of video involving police officers. Current motivations, interpersonal goals may create attentional biases towards or away from African Americans, and group identity. People interpret the reasonableness of the police behavior depicted in a video differently depending on their cultural and ideological backgrounds. So, despite people's intuitive faith in video evidence, visual interpretations can vary widely and are subject to a host of influences of which people remain largely unaware. And this brings us to the subtitle of the talk today. Documentary filmmaker Eros Morris famously said that they say seeing is believing, but actually the opposite is true. Believing is seeing. Oftentimes, our beliefs are imposed on how we interpret and see images. And by this point, I really hope to highlight why it's important to pay attention to how visual perception and interpretation work in court and why that's important to understand and study and analyze at times when video proliferates in courts. So, how do we deal with video in court? What are some ways forward? What are some areas that are interesting to research? And now, Judge Kennedy and I yesterday had a great conversation where we talked about some of the similarities and differences between eyewitness testimony and video and what some of the literature has said on these questions already. So, similarities and differences. Here's just me finding a graphic on factors that influence an eyewitness testimony and just thinking about video evidence in court. But let me talk through some of the similarities. What's interesting about both is that people place too much trust in their own perception and interpretation. In other words, they tend to overbelieve what they see, what they hear. People overestimate the reliability of eyewitness testimony, just like people overinflate the probative value of video evidence. Both video and eyewitness testimony can be preferred without expert analysis, requiring jurors to assess the credibility of the evidence on their own. Now, the context in which the evidence is gathered, such as lighting conditions or field of view, as well as factors external to the decision maker, may affect the perceived credibility of the evidence. What are some of the differences? The facts that videos are preferred to establish, may often be more ambiguous than the distinction between true versus false testimony. And we know that ambiguous contexts are more subject to bias, so video can be potentially even more prone to biases than eyewitness testimony. Video gives the impression of a firsthand experience of events. Thus, people rely on their own confidence rather than the perceived confidence of the eyewitness. Now, video, unlike eyewitness testimony, doesn't change. and it can be reframed in various different ways, both verbally and visually in court. And this is where I come in and I say we need scientific guidance for video evidence. Now, if you follow the series through December, you'll get to hear more about the research and the work I've been doing as part of my Mellon ACLS fellowship with SciDec. But some of the things that I'll mention here is that a big chunk of the work has been to conduct a systematic analysis of the use of video in state and federal courts between 1990 and 2020 in criminal, immigration, and Indian law. Now, why do I need systematic analysis? Because a lot of what we know about how video is actually used in court has been based either on highly publicized trials or trials of high profile. So though we have good educated guesses about what's going on in court, we don't quite know, for example, the prevalence of naive realism as strategy to frame videos or as an epistemological stance towards the interpretation of video. So I think that before we start thinking about guidance, we need better systematic understanding of the problems and challenges involved. So methodologically, I've been looking on Nexus Uni for federal trials with the key term video evidence, identified over 5,000 cases in criminal law, 75 in immigration, and only 8 in Indian law. But there are difficulties and challenges in obtaining the video evidence. US courts don't archive visual evidence. So we are beginning the tedious work of sending requests for footage from courts, lawyers, and newsrooms to obtain the videos, because I do think a parallel analysis of the legal documents and the videos is necessary to understand the challenges that we are talking about. Preliminary analysis reveals that naive realism appears both as a rhetorical strategy and an epistemological stance. What do I mean by this? Rhetorical strategy is when litigants tell jurors, believe your eyes, what you're seeing is the truth. We've seen it in famous cases. It appears in other cases. Epistemological stance is where the assumption is that video speaks for itself and kind of urging people to interpret the video in that way. What are some of the next steps? It starts by building an online database of court cases and videos so that others can take a look at this materials, but also real cases and videos could be helpful for testing effective legal training and instructions for video evidence and thinking about the guidance. We are developing taxonomy of video evidence usage. In the future, I plan to do exploratory surveys for judges and lawyers, and really with the goal of developing criteria for video evidence guidance, legal training, and possible jury instructions. Now, if you're interested in more of this, we invite you to come to our other SciTech webinars. In August, as Laura mentioned, there will be a session on neuroscience with AAAS. September through October, we'll have 3 sessions: visual perception, interpretation, and persuasion. In November, there will be a roundtable discussion with practitioners on visual investigation, preservation, and litigation, and 2 sessions in December, one on deepfakes and another specifically on police body cameras. Now, on that note, I thank you for your attention, and let's have a conversation and answer some questions.
Anyone?
I have one question. Hello?
Hey there.
Hi. Can you hear me well?
Definitely. I can
Yeah,
anyway.
thank you. Thank you very much for your presentation. Very good and really helpful. And do you know any company, enterprise, or website where you can find more
Judge
videos?
Kennedy, I see your comment here, which I think is excellent. You say that you sense that video may turn us into eyewitnesses where we have in other situations listened to eyewitnesses. Would you like to tell us more? Because I think this is excellent point and precisely at the heart of the matter.
Well, we were actually in the middle of a question, and the question started out with Is there anybody that does something? What was the rest of your question? Hello?
Yes, the question
Okay.
is
Is
if
it
you
just
know.
me or can everybody else hear you?
Well, it's Nelson Viamonte, who's speaking.
I can hear him.
Okay.
I can hear him.
Okay, it's just I would like to know if there is any website or any company or enterprise who gathered all those videos and we are able to like make subscriptions and get access to those places, or that those places doesn't exist.
The question was, is there anybody that's compiled the videos that you have used? I've seen most of those videos, and to tell you the truth, they are not hard to find on the internet. I think YouTube has a lot of YouTube is likely to have many of them. Certainly the people passing the basketball with a gorilla has shown up in any number of different places and is pretty common. I don't think you'd have a problem finding them. And but if you need more help, please get in touch. Basically, what to get back to Dr. Ristovska's question about our conversation yesterday, we were talking about the fact that, say, you and your friend are out in your front yard, your neighbor, and you see an accident, and some days later, you and the same friend are describing it to somebody else who did not see the accident, and and one of you says something and the other one corrects what it was that you said you saw. You were both there, you both saw the same thing at the same time. And I mean, this can happen in all sorts of different places, and in different contexts, but it points to the differences in how we perceive and we store and we recall, and how we're encouraged to emphasize things that we think about when we have memories. And eyewitnesses do that. We have lots of witnesses, expert witnesses who talk about that in the course of trials these days. And my suggestion, or my taking this project along, is that I think we need to, what Dr. Ristovska is talking about with scientific guidance and standards, is we need to apply the same sorts of things to how people process video, so we can use video more effectively. So, I mean, the bottom line for Ms. Broe is, we are getting a filtered perception, and and the filtration starts the second our eyeballs connect with our brain, and an image is stored. And we need to, but the same thing is, we become eyewitnesses, partly because of this naive realism, but because of our habit of thinking that video is a more direct reflection of reality, or is, it makes us the direct witness, rather than being an intermediate step in recording the fact itself, I think is the video question. At least that's the way I would look at it as a judge. Yeah, Michael Sachs.
Hello, everybody. Can you hear me?
I can.
Yes.
Okay.
Yes. So sorry.
Well, I guess I have two questions. One is, and maybe this is what you have planned for future sessions, kind of an overview of the questions, the the research questions you are
Mhm.
thinking of pursuing, because
Mhm.
just the preview you've given suggests there are a lot of possibilities.
Oh,
And
yes.
so maybe that's why you want to do the survey of what's out there. I mean, what kinds of videos people are seeing. But then my second, and then you probably will find, as researchers already have been finding, that there are factors that affect the interpretations people make. And then what is a court to do with that information? So, for example, if I remember the findings correctly, there was some research on confessions.
Mhm.
And if the frame of the video included only the suspect turned defendant confessing, people attributed the confession more to the suspect, that he really was confessing. There was no pressure on him to confess. But then when an alternative video frame was shown and you saw the beefy investigators and police around him, then people were more likely to attribute his confession to the pressure from the officers. So suppose the prosecutor comes to court with the first of those two scenarios, giving the jury an instruction that tells them about the problem. That in itself becomes a whole area of research to be done. Can you do that just by explaining it, or are you going to have to create videos to illustrate or borrow the research videos? Anyway, so those are a few things I'd welcome.
No, these are absolutely fantastic question. Actually, Lassiter and his colleagues who've done the studies on a camera perspective, they've tried to do different instructions-based intervention, and found mixed results. Alerting to the biases doesn't necessarily correct the biases. We know this from other areas in psychology research, right? So the goal of why I'm doing this systematic analysis, and I think Judge Kennedy and I have had conversation with this, but I've also had with other colleagues, it's because I really want to see what's happening in court. So I'm interested in how many and what kinds of videos are used in criminal trials, right? If the literature is telling us there is a difference between body camera and dash camera footage, okay, how are they used? Are they both used in the same case? Do we have just one video? Is there existence of another, etc.? So what kinds of videos are actually used? What facts is the video ostensibly being offered to prove, and how? And is it being used to prove facts beyond its scope? And if so, how? And right, this is why looking at both the videos and the trial transcripts, and I'm trying to do a representative kind of sample. So basically, I'm looking out of all the cases identified, and this is where I'm still in the process of gathering data, and this is the next several years, not just the SciTech residents. Is really looking at, okay, sample size with a 95% confidence, and figured out and studied carefully this research question through the trial transcripts, opinions, briefs, but also the video itself. Also, how does naive realism actually show up in court? How does it inform the arguments made in court? So what the lawyers say about the video, what their witnesses say about the video, and what, if any, additional visual materials are used to support and critique the video, and how. This is also important, and I'm gonna I saw one question in the chat, so I'm gonna bring this up again in response to that question. And beyond the naive realism, what rhetorical strategies there are. So I think these questions are for the development of taxonomy, and I'm hoping that this taxonomy would be the basis for identifying the most common issues, and then figuring out guidelines based on that. And the survey is intended to really supplement the taxonomy with the opinions and decision making that judges and lawyers do in court in regards to video. And so this is really kind of future steps, and why I'm undertaking the research that I am. I don't know whether that helps in the direction of where we're heading. Okay, now somebody, okay, Ruth has a question and then I'll go back to the chat, but very briefly, somebody is saying in the chat that isn't video still the gold standard? Where would we be without George Floyd videos, and recall the riots that broke out when the videos of Rodney King were manipulated to protect police? Okay, I'm not saying don't include video as part of the evidence, right? This is not what we are saying. And eyewitness testimony was at some point a gold standard in trials, right? But this is not to discredit testimony. This is not to discredit video. But if you think about George Floyd and how is George Floyd potentially similar and yet different from Rodney King? In Rodney King, the prosecutor said, the jurors believe your eyes. And that was it. See the video is what it is, and that's it. George Floyd, the prosecutor told the jurors, believe your eyes, the video is exactly what you saw. They brought in a lot of experts witnesses that were saying basically, you know, one of the pathologists was saying some of the differences you see between these two frames on the body camera are not significant for lay interpretation, but they're significant for an expert. So kind of saying seeing is incomplete. I'm seeing things you're unable to see. And then also there were multiple other videos, from the dashboard camera footage to the police body camera footage to the surveillance camera in the store, not just the cell phone footage. And so you had multiple different videos from different angles that were being portrayed there. So it's not even, I would say, a case with one video, and neither of those cases tells us not to use a video, but we have to be more careful with how we're using video and the potential biases in perception and interpretation of video, if that helps answer the question for the chat. And Ruth has a hand up.
Yeah, this is Ruth here. This is such an interesting presentation, really stimulates a lot of thoughts. One thing that I think about in connection with this is all the concerns that have been expressed about AI generated deepfake videos that are spread, especially are spreading over social media. There's concern about how much it may have influenced the 2020 presidential election and future elections. And we know that social media tends to be an echo chamber, you know, a lot of the pushing things based on your own way of looking at the world. And it's becoming increasingly, I mean, the concern is that not just in elections, but like you could see a corporate CEO or a celebrity, you know, saying something, you see them, you hear them, and it's not really them. And the ability of these deep fakes can be very sophisticated or not, you know, and you can spot it that it's fake. But I think that our ability to generate these things is greater than our ability to attack them. And we hear so much about, quote, fake news that people think, well, I just saw it, but that's fake news. So how does that play into all of it? It's a whole nother layer, it seems to me, on top of this.
Yes, please do come to our session in early December on deepfakes, because we're going to be tackling this in great depth. One thing I'll say, and this is a little history, one of the first court cases where photography was put on trial is the spirit photography case in New York, right? Where Mumbler was at court for fakery. Was he really taking photographs of people and their spirits, or was that manipulation, right? Jennifer Monakin, who is a dean at UCLA Law, has a fantastic article on this case, and really kind of she traces the history of demonstrative evidence as a doctrine to govern images back to that case, where like really the status of photography as evidence was being debated and whether it's fake or not. Now, I'll go back even earlier in time and say that Napoleon used paintings to manipulate public opinion and to depict things that were not there while portraying them to be true, right? So I think the deepfakes are part of longer history, and each time a new visual technology comes about, that has the potential for manipulation, we hear this kind of response of anxiety about the status of visual evidence. Now, of course, social media and AI exacerbate the problem, but I think it's important to think about deepfakes as an evolution, an exacerbation of older problems rather than a uniquely new problem of our time, because that may help us with some ways forward. But I do think that even with deepfakes,
We lost your sound.
how about now?
Got it now.
Okay, I'm never using wireless headphones and microphone sets again. I was going to say it's important to think about as an evolution and exacerbation of older problems rather than a uniquely new problem, even though the technological sophistication makes them far more challenging. But I think a human rights organization that works on deepfakes says prepare, don't panic. And I think that's the right motto and approach for this. And there is a set of cultural, technological, and legal responses to this. One involves visual legal literacy on top of that. But I also think that some of the standards and guidance for video evidence that we're talking about here will become even more important with the rise of deepfakes.
Yep.
But do come to our session in December.
Yeah, one of the other things that we're seeing, particularly with the polarization question, is, I mean, autocrats have said for a long time, Napoleon, I'll blame today, that the bigger the lie, people will swallow it more more completely, and and so many people just refuse to believe anything that comes from a source as opposed to what the content is. I mean, anything that comes from a source is inherently believable or not. And the polarization of what to believe and from whom is certainly becoming a bigger and bigger problem as well, and showing up in court. I mean, getting back a bit to the naive user syndrome. I remember in a CLE that I was teaching about, eyewitness evidence came up, and I asked judges who were there, witnesses are not allowed to testify. A witness is not allowed to testify that another witness in the case is a liar. And how many, and among the judges, how many of the three who were there might believe that expert witnesses testifying that eyewitnesses can have problems that would render their testimony unreliable, were actually commenting on the truth coming out of the eyewitness, as opposed to things that can affect the quality of the truth that the eyewitness is saying. And 2 out of the 3 said that they would be inclined to exclude experts about eyewitness testimony as people who are commenting on the witness's veracity rather than their ability to process information. So it takes an awful lot of work to get from point A to point B, and convincing courts. Stare decisis is becomes the law of science as well as law sometimes, and we've always done it this way. Is a big hurdle to get over, and that's where more established standards and understandings become so important. Anybody else?
We probably do have time for one more question. So
yeah, we have an easy 5 minutes left.
Is this really new when you think about the fact, as you just indicated, that people see things through filters? And even if you're a live witness, the ability to have different recollection or different perception this just takes that to a new level, I think.
Yes, it's not new, and it's something which is why. So little personal background: I started studying the use of video, activist and bystander footage in particular, at international criminal courts. So I looked at the Yugoslavia Tribunal, which, as a first of its kind, had to deal a lot with VHS tapes from citizens, activists, bystanders, people trained by human rights organization, et cetera. And they had to figure out how to use them as video evidence. And as I was presenting on that work in different venues, sometimes kind of implicitly, sometimes explicitly, people said, well, those are international criminal courts. They have loose, flexible standards, they incorporate different legal traditions, et cetera. If you were to look at an established legal jurisdiction, you wouldn't find those things and those problems. And that's how I really started then delving into the US context. I say, okay, I live and work in the US now. Let me look at what is happening here. And so despite long-standing and wide-ranging research in visual communication, in psychology, in neuroscience, in legal theory and analysis, US courts don't have guidance, rules, and standards for video evidence. So people have been pointing to some of these things. Now, I think it's important to note too that video is different from photography. So some of the challenges it introduces are different from photography, right? It's not just image, it's sound, but also today video is metadata too. And on our police body camera panel, we'll hear about how video can be considered on the spectrum of other data collection devices that we have to think about storage and privacy concerns with the metadata, right? So video introduces certain kinds of challenges. So again, exacerbates the problems. And given its ever-growing ubiquity, I think scientific guidance is important and necessary. And I'm certainly not the only one studying this, nor should I be the only one studying this, nor we can, come up with answers in short time. This is something that I really plan to do for the next many years.
Well, our hour being up, are there any other questions? Being an appellate judge, we can always extend the time a little bit. Thanks, Ruth.
Thank
And
you.
thank all of you for coming. Professor Sachs, thank you for being here. And all of you, Mr. Teresko, and your question as well. It's an important thing, and it's been a real great thing for me to be part of this. And thanks to Dr. Ristovska for her research and kind of getting us in on I don't know, 2 flights up from the ground floor in her research. So thank you very much.
Thank you, guys.